Peace, everyone. Peace, everyone. Yusuf L here. What's happening? What's happening? What's going on? I'm checking this stream. Y'all tell me how this look and everything. I'm gonna have to check all these streams. I'm dealing with different settings and things. Yeah. Looks snazzy. Okay, cool. All right, cool. Let's go. Y'all ready to go? All right. Audio good? Everything good? Okay. All right. Today we're going to have a discussion about private ordering. And I'm going to give you the realities of it. And it's going to be parts that probably a lot of people do not really like in this particular space because it kind of goes against the narrative that you can do whatever you want. The government is your public servants. And, listen, in the beginning, when I first got into this, a lot of people weren't going into the court saying you don't have jurisdiction over me. Everybody was doing what was called acceptance for value. And because the whole thing was predicated off the fact that the gold and silver had gotten taken away, and therefore the nature of the courts had changed as a result of that there wasn't any money to pay for anything with. But it never was something that contemplated that they don't have jurisdiction over you and you can do whatever you want. And you can drive automobiles around, and there's a difference between driving and traveling and all this. All this is going off the rails. It was about addressing the debt that each and every time you went into court, um, it was a civil matter, and and in the background there was some sort of debt obligation that was owed, and that is what you would address, and that's what you would attack. Not saying that I am, and the only reason that we would make a distinction between the straw man and the real living soul is because the straw man was a bankrupt entity, and the real living person was real and capable of holding a bond, and therefore had value. So the distinction between the artificial person and the real living soul wasn't so you can say I'm not that person. Those weren't what the arguments that were being made. It was done so that you could understand you're making it was called rebutting a presumption. There was a presumption that you and the straw man were amalgamated, and thus you had the status of a debtor. However, everything in the public is bankrupt and everything in the private is not. And that's why you were making the distinction between the real living soul and the straw man. Not to say I'm not that person arguments. Not that person arguments hijacked this whole entire thing. I remember when no one was making those arguments in mass. Now everybody's making those arguments in mass, and they've overflooded the courtrooms with it. So today, what we're going to do is we're going to take a look at the realities of private ordering because I want people to get a proper, uh, I want to manage expectations because a lot of people they're looking for something that doesn't exist. They're looking for some way to escape the system completely and totally, and that does not exist. Okay, you don't have your own court system, you don't have your own enforcement mechanisms, you don't have your own gold and silver, you don't have complete sovereignty in the way that you would like to have it. Just doesn't exist. Okay, that's why my approach has always been understanding the system and how you can reduce any type of liability that is associated with the public when you come into contact with them. And that is essentially what private ordering is. And it is something that's been around for a very long time, thousands of years. And as a matter of fact, there are books written on this of societies of people like I think the cattle ranchers or the sheep ranchers. They've been using it for a long time. They use arbitration agreements. They don't never go into a courtroom or anything like that. Arbitration agreements is a part of private ordering, where you contract and you elect to resolve your disputes outside of the public forum. Okay, it doesn't matter if you buy your car from a foreign manufacturer, if you're going to drive them on these roads. This is what I'm saying. What it doesn't seem like y'all can grasp the concept. It's a public safety issue. It doesn't matter where you get the car. You can buy it wherever you want to. If you don't want to have a license or anything like that, you need to drive it on your own private property. But as soon as you hit one of these concrete paved roads outside of your private property, you have subjected yourself to a public regulation. Now, if you don't believe that, I don't know what to tell you because you don't have anything in writing to substantiate your position. All the court cases go against you, and history goes against you. So I'm not really sure. I don't know what to tell you. You know, right to travel is should be a dead issue. You need to leave that alone. That's all I'm going to say. It's not a it doesn't matter if it's public or private. See, this is something you got to understand. It doesn't matter if it's public or private. It's substance over form. If you come into contact with the public, it doesn't matter what you are public or private. You immediately fall under public regulation. They don't care what you call yourself. If you're going to call yourself private, then stay in the private domain. That is what they're saying. Do not come into the public if you're private. You can't call yourself private and walk around with a label of private and then think you can't be touched. Nah, that's why you've been seeing me say for 7 years that you don't understand public and private, because you don't understand that you think that labeling yourself private protects you. That's not how this works. That's not how it works. That's not how it works. You need to get rid of all that stuff. Okay, you need to get all the stuff you've been told. I go get me a private car from the manufacturer and it don't have a VIN number on it and all this. Just get rid of all of that because that's not how this works. It doesn't work like that. All right, so those arguments fall on their face because they're off-point arguments. They're not addressing the issue. The issue is public safety. Okay, you operating a 6,000-pound piece of metal down the road that's capable of killing another person. That is the issue. Not what you call yourself, not the definition of the word driver, not that it's a commercial term, not any of that. It's not any of that matters. All right, so we want to make sure we get an understanding of that. All right, so I put together a document. I put together a document. And it's called The Realities. What this is right here. Called The Realities of Private Ordering. Okay, so I put this document together because I wanted to manage expectations because as you come in, this is where you're all going to be moving to within the next year, regardless of whatever your ideology is, as AI and more researchers and everything come into an understanding of what's really going on. They're all going to come into that this is the pathway for you to take is private ordering because it is something that is the law recognizes in the public. It is something that has been around for thousands of years. It is the traditional way of managing your private affairs. All right. So you don't have to keep looking for some holy grail or anything like that. This is the answer you've been looking for. There is no other answer outside of it. I don't know what you're going to do or what you're going to look for, but this is the answer that you're looking for. It's called private ordering. All right. So today we're going to explore private ordering a little bit. Oops. All right. Realities of private ordering. Now, there is a link under this video for this document. I've made this document available to you. It is a handout that I've made available to you. It's approximately 22 pages long. You can download it right now, circulate it around the internet. That's what you should be doing and researching this. If you want to research it, you want to You put it in your chat GPT or your Claude or whatever. You're welcome to do any of that because it's going to pass scrutiny from any type of uh, independent investigation that you subjected to. All right. So SBC University handout, the realities of private ordering, what it is, where it operates, and where it stops. Second edition foundational handout. Read before any instrument is drafted. The central proposition. Private ordering is real, powerful, and extensively protected by law. It is also a permission the law grants, not an exemption from law and not a space the law cannot reach you. Okay, that's the first thing that we want to make clear. It's not some magic protection where you have some magical immunity where you can go around the country and do whatever you want, right, do 100 miles an hour through speed zones and nobody can pull you over or anything like that. None of that stuff exists. Every private instrument that works because a public rule says it can work. And this is basically predicated off the fact that ultimately all roads lead to a public court system. Okay, for you to get eventually, if you're going to get any type of ultimate remedy for some sort of dispute that you have and you can't rectify it privately, you're eventually going to have to resort to a public forum. And in history underscores this in every private institution in some shape, form, or fashion is subjected to some sort of public regulatory authority. The Rule 144D of the securitization of the private placement and all of that, that's an example. Even though it's private, you're coming in a regulated space. So you have to get permission. The only time you don't have to get permission is when you're completely private, and the only time you're completely private is when you own private property. Your own private property. Okay, you can't come off your private property and think that you can engage in public regulated spaces and still retain the status as private. That doesn't work. Every private instrument that works because a public rule says it works. A contract binds because contract law makes it bind. A trust is respected because trust law recognizes it. An arbitration clause displaces a court because a statute directs the court to step aside. This is not a limitation on private ordering. It is a mechanism by which private ordering exists at all. A student who understands this will use the doctrine well. A student who believes private ordering operates outside or above the law will misuse it, lose, and often pay penalties for the attempt. Who is this handout for? This handout addresses a specific and reoccurring error, the attempt to assert private rights inside a publicly regulated space on the theory that the private character of the parties or the instrument removes the activity from regulation. That error is worth taking seriously rather than dismissing because the instinct underneath it is sound. There genuinely is a broad domain in which persons govern their own affairs by their own terms, and the law protects it vigorously. The error is not in caring about private autonomy. The error is in looking for it in the wrong place, with the wrong instrument at the wrong time, and in mistaking a question of political philosophy for a question of positive law. This handout is written to give you the map where the private domain actually is, how large it actually is, what instruments may actually reach into it, and what will happen if you deploy them outside of it. All right, so the tag settled, meaning being holding or rule so uniformly applied, it is not seriously contested. That's when they say it's settled. Contested, genuinely unresolved, split or recently changed, cite with the disagreement disclosed, and structural, a consequence of how the legal system is built, not of any single case. All right, and then we have state law varies, determined by the law of a particular jurisdiction, verified locally before relying, and scholarship, not authority. A treatise, article, and empirical study may be excellent and may be wrong. It binds no one and settles nothing. Where scholars disagree, the disagreement is stated. All right, so everything in here you can substantiate. Part 1, what private ordering actually is. 1.1 definition. Private ordering is the use of privately created instruments and privately administered institutions, contract, trust, entity documents, association rules, arbitration, and other private dispute resolution to govern a relationship in place of the terms a public institution would otherwise supply. The scholarly literature is substantial and empirical, not speculative. Robert Ellickson documented Shasta County ranchers resolving cattle trespass disputes entirely by neighborhood norm, largely unaware of the actual law of trespass. I mean, they don't even know what the law is. They've been resolving their disputes. They never go to the public. That's a problem. A problem is a lot of y'all go to the public, like in child support. Child support is private law, but y'all initiate that. The public don't come to you. You come to them. Either the woman goes to them to get some welfare, or she goes to them to put you on child support. The state doesn't initiate that. You initiate it. If you can find some other kind of way to resolve that dispute, never have to go inside of a courtroom, you can do that. Lisa Bernstein documented the diamond trade operating for generations through internal arbitration and reputational sanction, with essentially no recourse to courts, opting out of the legal system. And these are the books you can go, you can check out right now. Order Without Law: How Neighbors Settle Disputes is in 1991. I just looked it up on the internet. And then Opting Out of the Legal System, right there in 1992. And the cotton trade doing the same through industry rule books. Settled: A Description of Observed Practice. There are studies, not authority, but they establish that the phenomenon is real and large. Is settled. 1.1, The Historical Pattern and the Myth Built on It. Private ordering is ancient. Merchant, custom, guild regulation, fair and staple courts, ecclesiastical jurisdiction, marine insurance, bills of exchange, letters of credit, and trade association rule books all long predate the modern regulatory state. Students are sometimes told that this provides private law once operating in a legal vacuum, and that is later subordination to statute was a usurpation. All right. The history does not support that reading, and the careful historical work cuts the other way. It's been everybody's contention that we're under the common law, and common law existed prior to statutory law, in which that it did. But the common law incorporates the statutory law. That is something that seems to miss people, and something that I always marveled at, because all you have to do is read the definition of what common law is, and common law is judge-made law. Common law is case law. Okay, who adjudicated the common law? The judges did. Okay, if you brought a dispute before a judge, okay, and it's not written down because you're going by custom, okay, well, the judge is going to hear both sides and they're going to write down the opinion. Even though the common law is not written law, when the judge writes down the opinion, he's using the customs and the principles of the common law to make his decision. Okay, and this is why you have to read the case law to see how common law was adjudicated. And common law incorporated also statutory law because the government, they have a jurisdiction as well. And it is sanctioned by the Constitution. Article 1 courts are in Article 1, Section 8, Clause 9 of the Constitution. What do you mean it's unconstitutional? It's right there in the Constitution. And then if you're talking about Article 1 courts are sitting in admiralty, well, admiralty is Article 3. Every time you make the admiralty argument, you're actually arguing for an Article 3 court. You're not arguing against it. This is how dense people are out here, because nobody has ever questioned that. How are you arguing and saying, well, this is an admiralty court? Well, admiralty is enumerated under Article 3. If you're saying it's admiralty, you are saying it's Article 3. Do you understand what I'm saying? All right, so 1.2, the historical pattern and the myth built on it. Private ordering is ancient. Merchant custom, guild regulation, fair and staple courts, ecclesiastical jurisdiction, marine insurance, bills of exchange, letters of credit, and trade association rule books all long predate the modern regulatory state. Students are sometimes told that this proves private law once operated in a legal vacuum, and that its latest subordination to statute was a usurpation. The history does not support that reading, and the careful historical work cuts the other way. The law merchant was not what it is said to have been. The Romantic account, a universal autonomous body of merchant law generated spontaneously by traders and enforced independently of political authority, has been substantially dismantled. Medieval merchant courts largely applied local law. Their authority came from town charters, fair franchises, and royal or seigneurial grant. And this picture, and the picture of a unified transnational lex mercatoria, is in large part a 19th and 20th century construction read backward onto the sources. Emily Cadens, The Myth of the Customary Law Merchant, and she wrote that in 2012, and The Medieval Law Merchant, The Tyrant of a Construct, written in 2015. The Modern Distortion of the Medieval Law Merchant, written in 2006. Now, I'm going to say this. These are modern interpretations. I would look for uh, some older sources as well, because I'm always skeptical of a lot of the modern sources because they will change things out. If you want to really read something and read what it really is, go to the ancient interpretation of it. Scholarship, not authority. Read Cadence before reading anything else on this subject. The myth is in wide circulation and is the intellectual feedstock of several failed legal theories. The same rule is true of the other examples. Guilds were chartered corporations, exercising regulatory power delegated by a town or a crown. Ecclesiastical courts were organs of an institution asserting its own jurisdiction, a competing sovereign, not the absence of one. In each case, there was an authorization layer. It was simply not the modern administrative state. Even the strong cases for stateless order is contested. The best known scholarly claim that a trading network enforced contracts purely through reputation without recourse to legal institutions concerned the 11th century Maghribi traders. Abner Grief, Contract Enforceability and Economic Institutions in Early Trade, the Maghribi Traders Coalition. 83 American Economic Revised Statute, what is it, 525? I don't know what that resource is. The account was reappraised on the documentary record with the conclusion that these merchants did in fact make substantial use of formal legal enforcement. Jeremy Edwards and Sheila Ogilvy, Contract Enforcement, Institutions, and Social Capital. Now I'm going to tell you something else. I would strongly be circumspect about some of these too, because these weird names let me know that they're I check the nationality of these people. And also, if you look the dates of these things are written, they're modern. Check old resources. The debate is unresolved. Note, what is the debate about? Not whether private ordering existed, but how much formal legal enforcement stood behind it. Even the limit case trends toward more law, not less. And I can understand that, because how are you going to get something enforced? Yeah, you can have private agreements, but what if you can't reach a resolution privately? You have to go to the public. This is what this is talking about, that at some point, no matter how private you claim to be, you may have to resort to the public to get some sort of remedy. I was just watching the other day when somebody said I'm making a special appearance and that I'm private, I'm the real living man, and you don't have jurisdiction over me. And then the next statement out of his mouth is, okay, I got some questions I want to ask the prosecutor. Well, you're participating in it, okay? That's what a public figure is, a person who willfully participate in public controversy. You can hit Black's Law Dictionary and look it up right now what a public figure is. A person who willfully participates in public controversy. You've left the private and you're now in the public. What actually holds? Real historical variable. The question that discriminates is not did a state exist, something always preceding the modern administrative state. The question is what made compliance rational. Historically and today, private ordering is sustained by one of two things: an authorization layer, charter, statute, court recognition, enforceable judgment, or a closed community with repeat dealing, dense information flow, effective sanction, and high cost of exit. This is where you want to try to get to right here, this closed community. That's why I was telling you earlier, you have to really be private, you need to do it as a community. You need to get some land set aside, maybe some acres, and then everybody is there by contract. And if there's going to be any type of, I think this is what the people in Waco and Dr. York and a lot of other individuals who attempted to do this, they went out and got acres of land and then ended up getting raided by the feds. Well, the feds, they acknowledge private ordering. If you were to get a contractual agreement from everybody who's planning on being a party to the community and make them sign the agreement, the courts will enforce that. However, they're not going to enforce things like you molesting children and doing things like that. That's not going. You could not have some private society where you are, participating in some sort of debased type of conduct. Okay, you're probably your contractual agreements are going to get ignored. Remember, you cannot contract and violate public policy. I'm just giving y'all the framework of all this stuff works so y'all can stop this ridiculousness because you don't understand what privacy is. You use the word of lot, but you have been interpreting it as you can do whatever you want to do. You cannot do whatever you want to do. It's you can do whatever you want to do as long as you don't violate anybody else's rights, and that includes the public. The public has rights too. So Ellickson's rancher and Bernstein's diamond dealers are the second kind. That is why their systems work so well and why they do not generalize, strip the community, and the norms lose their sanction, at which point the arrangement is an ordinary contract enforced by an ordinary court. Even then, the two are not separate. Parties who never litigate still bargain against what a court would do if they did. Robert Mnookin and Luke, okay, that's a good point to point out. A lot of times the reason you resolve things privately through some sort of arbitration agreement because you've already taken into an account the cost if we had to go into the public forum. So the public is always a consideration in any type of private arbitration agreement. The shadow is part of the mechanism. The court is for public argument, but you need to keep your affairs out of the public. We see this every day with private trusts. You can form a private trust. The object of the game is not to go into the courtroom. But in order to accomplish that, you have to structure it correctly, and it has to be administered properly. If it is administered properly and structured correctly, you'll never end up in a public forum. But when you read case law of trust, these are people who ended up in a public forum. They made a mistake. There was an agreement. Something wasn't drafted correctly. There's an disagreement on the meaning of something because there's ambiguity. And they had to resort to a public forum to have that resolved. But if you're going to be private, then you have to administer your affairs privately, and that has to be done the right way. If you don't do it correctly, you're going to subject yourself to some sort of public regulatory authority. So the historical lesson is therefore the opposite of the one usually drawn from it. Private ordering is very old, and so is the authorization layer or above it. The pattern in subsection 1.3 is not a modern imposition on an older freedom. It is how things have always worked. That's what I'm saying. You don't have any historical evidence to substantiate that I can move privately the way that you're trying to move privately. You don't have any precedents of that in history anywhere. So 1.3, private ordering is a delegation, not an exemption. This is the proposition of which everything else in this handout depends. The delegation principle. Ask any private instrument, what makes this enforceable? If you got a private contract, how are you going to get it enforced? How are you getting your private contracts enforced if you're not coming into a public forum? That's the ultimate question. A contract is enforceable because the law of contracts applies a remedy for its breach. A trust is respected because trust law recognizes the separation of legal and equitable title. A corporation limits liability because the statute says it does. An arbitration award is binding because the Federal Arbitration Act, Title 9, United States Code, subsection 2, makes the agreement enforceable. And subsection 911 directs courts to confirm the award on narrow terms. In every case, the answer is the same. A public rule confers the effect. A public rule confers the effect. Remove the public rule and the private instrument becomes a piece of paper describing an intention. It follows that private ordering operates inside the legal system. in the space the system leaves open. It cannot operate against the system because it has no force independent of it. This should be common sense, but there are going to be people that are going to try to argue it, and that is why you know that this is outside their ability to comprehend, because this is basic common sense right here. But how are you going to enforce your private rights outside of the public? You don't have any. That's why a lot of y'all trying to talk about taking up guns, and that kind of talk is going to get you crushed by the federal government, because you're going to be looked at as a straight terrorist. The point is made most clearly by arbitration, the strongest form of private ordering in American law. Arbitration is the strongest form of private ordering in American law, is arbitration agreements. Parties may choose their decision maker, their procedure, their governing rules, and their remedies. What they may not do is expand the grounds on which a court will review the result. The parties cannot contract for a broader judicial review than the statute provides. This is why you have marriage contracts. Marriage contracts are a part of private ordering. You should have an arbitration clause in there, and usually they're religious, because marriage is a religious institution. From the ones I've seen, if there's a different agreement between the husband and the wife, the first thing they have to do is go to their pastor, their preacher, their imam, or someone like that, their rabbi. That's who they go to first, because it's a religious situation. If you're following the laws of God, okay, that is what marriage is. It's a religious institution. You removed it from it and taken it into the secular world and put it in the hands of heathens right now. But marriage has always been a religious institution where it needs to go back to. And it is a contract. Y'all going up into these courts because you don't know what you're doing. You don't know how to handle your private affairs. That's the problem. And it's like a judge said. He says it's a shame private citizens have to. It's a shame public servants have to tell private citizens what to do. That's what I heard a judge say. He says it's a shame public servants have to tell private citizens what to do. You don't know how to arrange your affairs privately and then administer your affairs so you don't end up in a public court system. One of the strongest ways of learning how to do that is to learn trust law. You're not going to learn trust law in a couple of weeks. And you're definitely not going to learn it in echo chambers. That's why we have like a 10-month course over. That's why I have a university. That's why you need to come to class every day, okay, so you can learn, and you'll begin to understand and see why it's going to take you 10 months to learn it. You may privately order the dispute. You may not privately order the terms on which the public system engages with your private order. 3 kinds of rules. Every legal regime is built from rules of 3 types. The entire question of what private ordering can accomplish reduces to identifying which types of government governs the matter at hand. Type of rule, default rules, supply a term the parties did not address. What private ordering can do with it, displace them freely. This is the home territory of private ordering, and it is enormous. Most of contract law, most of the law governing entities, most of trust administration, and most of commercial law consist of default. Like, for instance, when you have confessed judgment, okay, that's how in the car contracts, everybody got a confessed judgment in the car contract. That is private ordering, and that's why they don't have to come take you to court to come pick up the car, because you have a clause in the contract called confession and confessed judgment. Write that down. It's in every car contract. So that right there is a contractual term that you agreed to that allows them to pick up the car without going through any type of judicial process. Are y'all starting to get it now? Contract law is where rights can only be enforced through contract. Altering rules specify how a default may be displaced in writing. Okay, let me start over. All right, so these right here in this box right here, these are three kinds of rules. Every legal regime is built from rules of three types. The entire question of what private ordering can accomplish reduces to identifying which type governs the matter at hand. Default rules supply a term the parties did not address, displace them freely. This is the home territory of private ordering, and it is enormous. Most of contract law, most of the law governing entities, and most of trust administration, and most of commercial law consist of defaults. Altering rules specify how a default may be displaced. Writing, signature, conspicuousness, magic words, filing. Comply with them exactly. A displacement attempted in the wrong form fails, and the default snaps back. Most drafting failures are altering rule failures, not substantive ones. And mandatory rules apply regardless of party agreement. Nothing. These cannot be waived, disclaimed, contracted around, restructured around, or opted out of by any instrument, however drafted, and regardless of the sophistication or consent of the parties. The framework is developed by Ian Aries and Robert Jerkner, filling gaps in incomplete contracts, an economic theory of default rules. And that's at Yale University, 1989, and in the subsequent literature on altering rules. The distinction appears in the statutory text itself. You do not have to infer the line. Commercial law draws it expressly under UCC 1-302. The effect of the code's provision may be varied by agreement, except that the obligations of good faith, diligence, reasonableness, and care may not be disclaimed, although the parties may set standards by which performance of those obligations is measured, if not manifestly unreasonable. Now, also, you know that the UCC is private law. Okay, however, as you can see, is there are provisions that that limit its effectiveness. Okay, it still is beholding to statute because you're going to have to go to the courts to get it enforced. You got to end up, all roads lead to court, even coming out of the private. Settled a single statutory section containing both the grant of private ordering power and its mandatory floor. Read it. It is the model for the whole subject, as UCC 3-102. Subject matter. Was that right? Am I, or is it, yeah, 130, is it one, oh, I put 3302. It's 1302, not my bad. Putting the wrong thing in here. Variation by agreement. Look at this right here. Variation by agreement. Looky here. Variation by agreement. Now let's get it over. Trying to get it on the screen where y'all can see it. Yeah, do it like this. Yeah, I might do it right there. How's that? Yeah, that's it right here. All right, so this is UCC 3-102. Variation by agreement, except as otherwise provided in subsection B or elsewhere in the Uniform Commercial Code. The effect of provisions of the Uniform Commercial Code may be varied by agreement. The obligations of good faith, diligence, reasonableness, and care prescribed by the Uniform Commercial Code may not be disclaimed by agreement. The parties by agreement may determine the standard by which the performance of those obligations is to be measured. if those standards are not manifestly reasonable. Whenever the Uniform Commercial Code requires an action to be taken within a reasonable time, a time that is not manifestly unreasonable may be fixed by agreement. The presence in certain provisions of the Uniform Commercial Code of the phrase unless otherwise agreed or words of similar import does not imply that the effect of other provisions may not be varied by agreement under this subsection. This is the whole basis of private ordering. Right here, it is UCC 1-302. As you can see, you can alter the UCC to a point, okay, but you cannot eliminate good faith, diligence, reasonableness, and care prescribed by the Uniform Commercial Code. You cannot disclaim those. So it's telling you what the limits are. However, you can displace a lot of it by agreement. This is the function of private ordering. I don't understand how anybody could, like, this has been in front of your face, but yet nobody's shown it to you. All right, let's get back to our document. The realities. That was good. That UCC 1-302. This right here is powerful. This right here is powerful. As I said, this document is in the description. You can push the link and you can download the document and you can use, because I'm giving this to all of you because I want you to do your own research. I want you to research everything that I'm saying. Okay. And then prove it wrong if you can. You can't prove it wrong. It's not, it's right here, right in front of our face. 1.5, the reserve police power is a term of every contract. Okay, there is, even if it's not written in the contract, there are certain things that are just automatic. The court is going to consider a part of the contract, whether it's written or not, and that is police powers. Police powers are added variable in every contract that is written, regardless if you stipulate it expressly or not. You got to understand this. Parties contract against the background of existing law, and the sovereign's essential power are treated as incorporated into every agreement. The Supreme Court has long held that the reservation of essential attributes of sovereign power is read into contract as fully as though expressly written into them. Home Builders and Loan Association versus Blasdale, Volume 290, U.S. Reporter, page 398 and page 435, year 1934. That's settled. Okay, this is not a doctrine of hostility to contract. It is a doctrine about what contracting parties are understood to have agreed to. No instrument can be drafted so as to exclude it because it is a term of the instrument. All right, so it's impossible to write a contract without the background understanding that all roads lead to the public court system. This is the reality. This is real law. Let's go on. Part 2, the distinction being missed. 2.1, private names, 3 different things. Almost every failed private ordering argument rests on collapsing these 3. The sense of private party, what it actually means. The actor is not a government actor. This affects which body of law applies. Constitutional limits generally bind government, not private persons. Broadworth versus McDowell, Volume 256, U.S. Reporter, page 465 and 475, year 1921. It says nothing about whether the activity is regulated, much like right to travel. A lot of these people say we have a right to travel. You do. It doesn't say you have a right to travel unregulated. That's the part they always want to leave out. They just want to look at the case law, and they'll see in the case law where it says that you have a right to travel, and then just conveniently skip over the part where it says this activity can be regulated or that rights can be regulated. This is in every right to travel document you're going to read, but they won't look at that. They ignore it because they're lazy and they're not good independent researchers. Private relation. The relationship is created and governed by instruments between the parties. This affects what the parties owe each other. It says nothing about what either owes the public. All right. And private default rule. The governing rule in one is one the parties may displace. This and only this is the sense of which private ordering has power. The core error, these default rules. The core error. The failing argument runs, the parties are private, therefore the relation is private, therefore the rule is private, therefore we may set our own terms. Each that is non sequitur. Two private parties in a private relation are constantly governed by mandatory rules. An employer and employee are both private, so are landlord and tenant, a broker and a customer, a doctor and a patient, a lender and a borrower. Every one of those relationships is heavily regulated, and the regulation applies precisely because of what the parties are doing, not despite the fact that they are private. The test is not who the parties are. The operative question is never, is this private? It is the governing rule mandatory or default. Those are different questions with different answers, and the first does not predict the second. Congress has in several places voided contractual waiver expressly, which removes any argument about Securities Act subsection 14 and 15, the United States Code subsection 77N. Any condition or provision binding a person to waive compliance with the act is void, settled. Okay, this is not up for debate. Once again, you can see right here, you can make provisions, but you can't waive compliance. You can't make any provisions in your private contract that waives compliance. Once again, this is why you need to come. We're having a private ordering session essentially tomorrow with Mr. Brewer. Okay, you can go over to SBC University and sign up for this class tomorrow so you can learn how to do private placement memorandums and get a walkthrough on this. And, you know, I think he's going to go through it even a little bit more detail today because, you know, this is the second webinar. So now he understands what he's doing and how he's going about it. But you need to be on this webinar because this is what you are headed to. Everything else that out there that you're doing is nothing. It's just theory. It's just a mythology. This is the reality that I'm giving you right now. Everybody's going to be headed down this way at some point in the future. The test is not who they don't get, you know why a lot of people don't get the right information? Because y'all don't share it. Like, how many of y'all are sharing this live right now? Every one of you should be sharing this live right now. You should be posting it on your Facebook group. You should be posting it in the echo chambers. You should be making clips out of it and circulating it around. That's what you should be doing. That's why people don't get the information, because this is not sexy. This is not, you know, putting false, giving you, you know, a false reality that you can do anything you want to do, or that in some kind of way the government is evil and you're the good person. Okay, and the government is evil and we need to do something about the government. Okay, it doesn't buy into that narrative, so it's not sexy like that. So people don't want to hear that. They don't want to hear that. You think I like doing this? You know I lost 75% of my revenue going down this road because I'm not telling people what they want to hear. You think I like doing, you think I'm doing this for money? You think I'm doing this for money? If I was doing this for money, I'd tell you what you want. I'd do what everybody else is doing. And I make a lot more money than they were making because I could make a lot more fanciful, fancy promises than they can. But this is the reality. This is the truth. This is what you need to be trying to understand. You need to be learning about private trust and trust administration. That's where you need to put the bulk of your focus. Okay, these are all of the settled Exchange Act, Fair Labor Standards Act. Okay, you can't waive those provisions. All right, Standards Act rights cannot be waived or settled by private agreement because the statute serves a public purpose beyond the individual employee. You cannot. You cannot create a contract that goes against public policy. Anytime you come into contact with the public, you're going to be beholden to public regulation. That's something you have to understand. Private rights begin where public regulation ends. You got to understand that. That is the demarcation line that separates public from private. More generally, a promise is unenforceable on grounds of public policy where legislation so provides, or where the interest in enforcement is clearly outweighed by public policy against it. The nuance that matters, form is not right. Private ordering can change where and how the statutory claim is heard, even when it cannot waive the claim. A party who agrees to arbitrate a statutory claim does not forego the substantive right the statute affords. It submits to their resolution in a different form. So even if it is involving a statute, you can change the form. You don't have to go into these public regulated spaces to have a dispute resolved. This is essentially what has happened when you attempt to do an administrative process and you're trying to reach an agreement with a prosecutor. You're trying to change the form. You're trying to resolve this contractually. What changes when you enter a regulated space? A regulated space is an activity the legislature has conditioned. Entry is voluntary. The terms are not. Once inside, the regulation defines the activity. It is not an external burden laid on an otherwise unregulated private right. And this is something I've been trying to get y'all to understand, but because you don't understand public and private, you think that by labeling yourself private, you can move anywhere you want, and that label has to be honored. Private labeling is not honored in any public regulated space, period. 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 Okay, if you're going to stay private, then you have to understand how to move privately. That is a skill that you have to develop. That is a skill that you have to learn. It is not just a declaration and then you walk around and think that not everything has changed as far as your relationship vice versa with the public. The recurring student error is to treat entry into a regulated activity as though it were an ordinary private transaction with an unwelcome overlay, and then to draft an instrument disclaiming the overlay. The overlay is the floor of the room. It cannot be disclaimed from the inside. Regulated activity. Operating a motor vehicle on public roads, what the regulation actually conditions. A state may require registration and licensing and may condition use of highways. Hendrick versus Maryland. They always quote this, and right there in the case, it tells you this. They quote this all the time, Hendrick versus Maryland. Reach versus Mealy, settled. Note carefully, there is a constitutionally protected right of interstate travel. Sanchez versus Roe, and it is not a right to operate a vehicle unlicensed. Conflating the two is the single most common error in this area, and it's true because they interpret right to travel meaning that the mode of travel, any mode of travel that they choose, they have a right to do that unregulated. You can walk is a mode of traveling that's not regulated. A bicycle is a mode of travel. It's not regulated heavily, but they do have rules for you to be on the road and lanes for you to ride in. But an automobile is a dangerous vehicle. Offering or selling securities to the public, registration or a documented exemption with its own conditions and filings. Structuring a transaction privately does not exit the act. It selects a different compliance path within it. This is primarily what Mr. Brewer is trying to teach y'all. Tomorrow at 7 p.m. I really think that it is important for you to be in this class because you understand how securitization works, how you can make something from nothing, utilizing your creativity. You're never going to know it if you don't educate yourself and understand how the necessary steps you need to take. Once again, that's at SBC University. You can register there. Practicing a licensed profession, okay? Or I'm sorry, employing labor, wage, hours, safety, and withholding obligations that the parties cannot bargain away. Practice a licensed profession, licensure conditions attached to the practice, Styling the relationship as a membership, ministry, or private association does not alter what is being practiced. State law varies. Verify the definition of practice in your state. It is usually broad and conduct based. Serving food, lodging, or the public generally. Health, safety, and public accommodation regulation attaches to the conduct. A membership label does not convert a public-facing operation into a private one for regulatory purposes. State law varies. 2.4, the private law reason the state is not bound. There is a way to see this using nothing but private law, and it is worth stating because it is an argument students find hardest to dismiss. Privity. An instrument binds its parties. It has no effect on anyone who is not a party. This is elementary contract law, and no one disputes it. The state is not a party to your contract, your trust, your operating agreement, or your association bylaws. It did not sign, did not assent, and gave no consideration. Therefore, your instrument has exactly the effect on the state that a contract between two strangers has on you. None. Not because the state is powerful and not because courts are hostile, but because you cannot bind a non-party, and that rule protects you far more often than it constrains you. Structural. The same principle explains why a trust cannot defeat a creditor whose rights vested before the transfer. That creditor is also not a party. And that's right there. It should kill any notion of anyone out there telling you can stop a foreclosure by transferring a property into a trust. That is the biggest. They've been telling that lie since 2010. I've been fighting it since 2010. Like, what are you talking about? You can't stop a foreclosure just by transferring a house. There was already a contract in place. That contracting party is not a party to your trust. You don't change the character of the obligation by just removing the title and putting it into a trust. They're going to ignore all of that. And as a matter of fact, it might be judged as a fraudulent transfer and an attempt to evade creditors. Is most likely what you're going to get. To reach a non-party, you must use a public register. Section 2.4 states the limit negatively. Here is the same principle stated affirmatively, and it is the answer to what students in this area actually want. There is a way for a private instrument to bind the world. It runs through a public act. The law does not leave you with only the parties. It gives you a register, and the price of admission is disclosure. Secure transaction, a security interest attaches, becomes effective against the debtor by agreement, value, and rights in the collateral. UCC 9-203. That is pure private ordering, and it binds the two parties completely. It becomes effective against third parties only on perfection, ordinarily by filing a financing statement. UCC 9-308 and UCC 9-310. An unperfected security interest is subordinate to a lien creditor. UCC 9-317A2. Between competing perfected interests, priority ordinarily goes to the first to file or perfect. And this is why they have the commercial chamber, because somebody may use the same collateral to get a loan from two different people. Okay, well, the commercial registry is put in place, so first of all, to give you notice that somebody already has attached some sort of security interest in that collateral, and they have a priority perfected interest in the collateral, and you're at a bigger risk making that loan by giving it. That's why we have the commercial registry. I had to give notice to the world of private transactions that you've been engaged in. Should make sense. Same thing with real estate. Real property, a deed is fully effective between grantor and grantee on delivery with no recording whatever. Recording does not make the deed good. It makes it good against subsequent purchasers on terms set by the state's Recording Act. Race notice or race notice. That's if you want to come into the public and get something adjudicated, you need to have already something on the public record substantiating your position in this collateral if you want to come into a public forum and have it adjudicated in your favor. Once again, where are you going to get enforcement for your private contracts? You know, how they use enforcement in reputational type situations is your reputation, everybody will ostracize you and you automatically get eliminated from it. Nobody will do any business with you. That's a form of private ordering. It's reputational. It's a reputational system. Which is very powerful in private member associations. State law varies which of the three regimes your state uses determines the outcome. Know yours. Principle. A private instrument creates the right. A public act makes it good against the world. This is the mechanism students are reaching for when they attempt to bind non-parties by declaration, notice, or affidavit. The mechanism exists. It is not a declaration. It is a filing. It is a designated register in a prescribed form within a prescribed time. Note what the register requires in exchange. You must disclose. Third-party effect is purchased with publicity. An instrument designed to be both binding on strangers and hidden from them is asking for something the system did not sell. You got to give full disclosure. 2.6 worked example. Regulation D. A private placement is the cleanest single illustration in American law of everything in parts 1 and 2 because both halves are visible in one transaction. The parties write a great deal. None of the writing touches the exemption. What the parties genuinely order, subscription agreement terms, representations and warranties, indemnification, what no drafting can reach, whether the exemption is available at all. Rule 506B and 506C set conditions. The parties may satisfy them or fail them, not rewrite them. Transfer restrictions, certificate legends, rights of first refusal, drag along and tag along, resale limits, securities sold under Regulation D or restricted securities, Rule 502D, operating on partnership agreement, control, economics and distributions, deadlock, exit, the prohibition on general solicitation in a 506B offering, conduct governs, a recital that no solicitation occurred does not unring it. You can't write these out of the contract. Escrow arrangements, closing mechanics, side letters, information rights, accredited investor status, Rule 501A defines it. A person either meets the definition or not. Governing law form and arbitration of disputes between the parties. The Form D filing, Rule 503. Allocation of expense, fees, and costs of disputes. The anti-fraud provisions, never waivable in any offering by any party. See subsection 29A, 15 U.S.C. subsection 78 CCA, already noted at subsection 2.2. The sharpest point in this example, an investor's representation that she is accredited is evidence, not a fact creating an act. It does not make her accredited. It is nonetheless doing real legal work. Under Rule 506B, the issuer may rely on a reasonable belief that purchasers are accredited, and a well-taken representation supports that belief. Under Rule 506C, where general solicitation is permitted, representations alone are not enough. The issuer must make reasonable steps to verify. And that's it. That's what it is to be an accredited investor. You know, you have to be able to prove that you have $200,000 of disposable income that you can lose that won't affect you. But sometimes, in one situation, you made a representation of that. In another, it has to be verified. Even though these are private agreements. Students who work in this area should notice the pattern. The sophisticated practitioner's freedom is very large and very precisely bounded, and knowing exactly where the boundary runs is what the sophistication consists of. Part 3, legitimacy is not jurisdiction. Two separate questions. These are routinely fused, and the fusion is fatal to the argument built upon it. Question, is the government legitimate? What kind of question is it? A question of political philosophy and moral theory. It is answered with arguments about consent, natural right, social contract, and the proper ends of authority. It is a serious question with a serious literature. No court has jurisdiction to answer it, and no court needs to. It's a political question. Does this tribunal have jurisdiction over this matter and this person? A question of positive law. It is answered by reading a constitution, a statute, and a rule of procedure, and by applying them to facts. It is answered the same way whether or not the government is legitimate. The two questions have no evidentiary overlap. Nothing that would support an answer to the first is admissible on the second. A student who brings philosophical material into a jurisdictional motion has not made a weak argument. He has made a category error, and the motion will be denied without reaching it. Structural. 3.2, real jurisdictional doctrine is rigorous, and it is a better tool. The irony worth teaching. Jurisdiction is one of the most seriously policed concepts in American law. Courts raise it on their own motion, cannot waive it, and must resolve it before anything else. Federal courts are courts of limited jurisdiction. It is presumed that a cause lies outside that jurisdiction, and the burden of establishing it rests on the party asserting it. Settled. Jurisdiction must be established before the merits are reached. There is no hypothetical jurisdiction. Settled. Subject matter jurisdiction cannot be forfeited or waived, and may not be raised at any stage, Settled. These are real, powerful, frequently successful arguments. Removal defects, amount in controversy failures, absence of a federal question, standing defects, and statutory jurisdictional limits win cases every day. Teaching point. The folk version of jurisdiction is not a stronger version of the real doctrine. It is a substitute for it, and it displaces a tool that works with one that does not. A student who spends his effort on the philosophical version never learns the doctrinal version, and the doctrinal version is the one that would have helped him. And that's what y'all constantly engage in the echo chambers, philosophy. You haven't learned the actual doctrine of what standing and jurisdiction and all that is and what actually defeats it. The case is most often misread. Cheek versus United States, volume 498, U.S. Reporter, page 192, year 1991, is frequently cited as supporting the proposition that sincere disbelief in a legal obligation negates it. It holds close to the opposite, and the distinction it draws is the distinction this entire handout is about. Cheek held that a good faith misunderstanding of what the law requires may negate the willfulness element of certain tax offenses, however unreasonable the misunderstanding. Cheek also held that a belief that the tax laws are unconstitutional or invalid does not qualify. Such a belief does not arise from innocent confusion about what the law requires. It reveals full knowledge of the requirement coupled with a decision to contest its validity, and the proper channel for the contest is to comply and litigate, or to litigate without violating 498 U.S.C. subsection 204. In other words, you got to pay your taxes under protest if you want to challenge it. That's the proper steps to do that. The case draws exactly the line between an understanding and obligation and understanding it and denying its authority. Only the first is a defense, and only to the willfulness element. 3.4, why courts do not entertain the legitimacy argument, not because the question is unimportant, but because of what a court is. A court is an organ of the government whose legitimacy is being challenged, constituted by the same instrument and possessing no authority except what the instrument confers. A tribunal cannot coherently adjudicate the validity of its own source of authority. If the challenge succeeded, the tribunal would lack power to enter the judgment sustaining it. Boy, y'all need to really sit down and read that and meditate on what was just said. If the court is illegitimate, how can it issue an order dismissing something? The order is not, the order, you know what I'm saying? You got to think about what's being said, what you're saying. Just like with the same thing with the argument about, well, this court is sitting in admiralty jurisdiction. Well, admiralty jurisdiction is Article 3, Section 2. So are you arguing for this court actually being an Article 3 court if you're arguing for it to be in an admiralty jurisdiction? Is that what you're saying? If you're saying that it's an admiralty, then that is Article 3. This is a logical feature of adjudication, not a policy of any court. It would be true of a private arbitral tribunal asked to rule that its own arbitration agreement never existed. Related doctrines reflect the same structure, the political question doctrine. Well, I've always told you the political question doctrine. Individuals, they don't understand the political question doctrine, separation of powers doctrine, delegation of powers doctrine, all these things you need to understand if you want to understand jurisdiction. You need to understand these things. But you don't see anybody talking about them in the echo chambers. And if somebody comes and brings it to you, they want to start saying they're an agent. It's not that they're an agent, it's just you haven't done any real independent study into what the law actually says. All right. You just get on and you enjoy watching memes of individuals saying they just ran out of court and they just tried this. I made the appearance without making an appearance. Just I did an appearance without making an appearance. You just made it up. And you expect made up stuff to work in the courts. You're crazy. Part 4, how these arguments actually fail. Not why they are wrong, why mechanically they produce the outcomes they produce. Understanding the mechanism is what allows a student to redirect the effort productively. All right. 4.1, the 4 failure patterns. Okay, so here are your 4 failure patterns. Number 1, non-party binding. The instrument purports to affect someone who never agreed to it. Fails on privity of contract. You're trying to put obligation on somebody who's not a party to the contract. Mandatory rule displacement. The instrument purports to displace a rule that is not a default. Fails on the rule's own terms, often expressly voided by statute. Category error. A philosophical premise is offered where a doctrinal one is required. The tribunal has no procedure for receiving it. You're coming in with some philosophy and not doctrine. Label over conduct. The arrangement is renamed rather than restructured. Courts classify what is actually done, the substance of the agreement, the actual allocation of control and benefit, not by what the document calls it. Naming is the weakest possible legal act. A lot of you think by using names you change something. That's the weakest position you can hold. All of law goes with what is called substance over form. In other words, actions speak louder than words. Your conduct is what governs, not your words. Your words better be in alignment with your conduct. Pattern 4 deserves emphasis because it is the one that reaches otherwise careful drafters. The disregarded trust line is the standard illustration, where the settler retained practical control of the property and nothing about the beneficial enjoyment changed. Courts have treated the arrangement as a nullity for tax purposes, notwithstanding the formal documents. Well, this is a classic substance over form situation where you put together a private trust, but it's not administered like a private trust. Okay, nothing changed about it. You're still by yourself. You just put together a trust, no beneficiary, no property transfer in it. Okay, well, it's not going to save you for tax purposes just because you put together something called a trust. It needs to be actually conducted like a trust is supposed to be administered. All right, that's what they're going to look at. The IRS is going to look at that, and the equity courts are going to look at that. And you're going to see that's probably one of the number 1 doctrines in trust law is substance over form. Or principles, equitable principles. That's an equitable principle, substance over form. People are always screaming about equity. Well, start learning them. That's what we do at SBC University. We go over the principles of equity and learn how they're applied in actual real cases. What failure cost? This is not a neutral experiment. The argument in this family carry defined and frequently imposed penalties. Rule 11 sanctions. Claims must be warranted by existing law or a non-frivolous argument for changing it. The court may impose sanctions on motions or on its own. Excess cost liability. Counsel or a party who multiplies proceedings unreasonably and vexatiously may be required to satisfy the excess cost personally. Inherent power. Courts may sanction bad faith conduct independent of any rule or statute. Frivolous submission penalty. A civil penalty for submission based on positions the secretary has identified as frivolous or reflecting a desire to impede administration. Tax court penalty, up to $25,000 where proceedings are instituted primarily for delay or the position in frivolous or groundlessness. Title 26, United States Code, subsection 6673A1, settled. This is a second cost that is harder to see and usually larger. The meritorious argument is lost with the frivolous one. A filing containing a genuine jurisdictional or procedural defect alongside a legitimacy claim will typically be disposed of as a whole. The good argument does not get read. You mess up your argument. The practical rule: never mix registers. A motion contains legal propositions, record citations, and authority. Whatever else you believe about the system, it does not belong in the motion. Not because the belief is forbidden, but because including it destroys the instrument you're trying to use. All right, so now we get to the point of what private ordering actually delivers. If you've just joined us, this document is in the description of this video. There's a link. You can click on it and download this. I wanted all of you to have this because I wanted to manage expectations of exactly what private ordering is. Also, tomorrow we are having Mr. Brewer is having another private placement webinar. This is what all of this gets into. You know, these are the tools of the private. If you want to conduct business in the private, I think it is very powerful information. Especially if you want to get wealthy. If you're not looking to get wealthy, then maybe it's not for you. But if you have any type of expectations about getting wealthy, or you have some big dreams, or maybe you have a business or something like that, this is information that you need to know. This is information that you need to know. But only if you have some sort of vision in your mind. If you're content where you're at, then yeah, you probably don't want to go to this tomorrow. But you're going to have to invest in yourself and get some real information on, CUSIP numbers and ISIN numbers and tracking securities and the DTC and private placement memorandums and things of that nature. The more I'm into this, the more I'm seeing how it fits into what I'm doing as a secure party. Goes right into it, hand in hand, right? And also private trust. Private trust. You want to know how to do this, man. You may need to raise some capital instead of depending on banks. Raise your capital privately. That way you don't have to go through all this credit score mess and all this other stuff that, they're doing in the public. The real inventory instrument, 5.1 contract, what it genuinely accomplishes. Sets terms, allocates risk, defines performance, fixes remedies, liquidates damages, allocates the cost of disputes. Vast majority of commercial law is default rules you may rewrite. Choice of law. Party choice is honored where the chosen state has a substantial relationship to the parties or transaction, subject to the fundamental policy limit. Restatement second of the conflict of laws, subsection 187. Choice of forum. Forum selection clauses are presumptively enforceable and controlling in all but the most exceptional cases. Arbitration selects the decision maker, the procedure, the applicable rules, the confidentiality, and the finality. The strongest single instrument available. Trust separates legal from equitable title, governs succession without probate, specifies distribution standards, allocates fiduciary duty, provides for incapacity. Spendthrift protection is narrower than students expect. A spendthrift clause protects a beneficiary's interest from the beneficiary's creditors and does nothing for a settlor who's also a beneficiary. State law varies. Some states permit self-settled asset protection trust by statute, and I think Nevada is one. One of the things about this choice of law provision, it kind of ties into the trust, because when you go city shopping, you want to, depending on what type of trust you're putting together, that you need to elect the state that is going to have laws that are most agreeable to whatever type of entity that you put together. That is a very important point for you to understand. City shopping is very important as it relates to private trust. Once again, class tonight at 9 p.m. Central Standard Time. Entity structure limits liability, allocates control separately from economic interests, defines transfer restrictions, provides deadlock resolution and exit mechanics, subject to being actually operated as an entity. Private association, freedom of expression association is constitutionally protected. All right. Real membership governance, internal discipline, and admission control. You got freedom of association, so you can come together and associate yourself in a membership group and make your own rules. However, you got to remember, you cannot draft contracts that go contrary to public policy. The public policy is always operating in the background like software, okay, in the background that you can't see. Because all roads lead to court. Once again, my question, if you have a private agreement, even if you have an arbitration clause, if y'all can't reach a resolution and you have to go to the court, who are you going to go to have it resolved? Or to get enforcement if you can't get it enforced? I mean, you can resort to, picking up guns, I guess, and doing it yourself, but also now you're violating the public policy. Now you are bringing in the public. Agency creates authority in another to act for you and to bind you. This is one of the things we use in private trust. You get agents to go and conduct business for you in the public so you don't have to directly engage the public. Private dispute resolution generally, mediation, expert determination, industry tribunals, internal grievance procedure, often faster, cheaper, confidential, and preservative of the relationship. And I'm gonna pause right here because y'all got the rest of this. Well, actually, let's keep going. What time? How long I've been going? Okay, I got some time. Agency, how authority is created and how it fails. Agency deserves its own section because it is simultaneously a major instrument of private ordering and the most common point of technical failure in the instrument this institution students draft. Where authority comes from. Actual authority arises from the principal manifestation to the agent, as the agent reasonably understands it. Settled. Apparent authority arises from the principal's manifestation to the third party. Restatement third on agency. And ratification adopts a prior unauthorized act and gives it effect as though authorized from the outset. The rule students most need. An agent cannot create his own apparent authority. Apparent authority is traceable to the principal's manifestations, not to the agent's assertions in himself. This is the verification doctrine that I came with, this documentary footprint that traces back to the delegation of authority, that either is going to go back to some law, constitution, statute, rule, regulation, or something that they derive their authority to act from. It follows that no self-description confers power. Signing authorized representative, attorney in fact, or trustee does not make it so. The signature block is a claim. The source of authority is a fact and is found in the governing instrument, a statute, or a course of conduct by the principal. Once again, that's where the verification doctrine comes in. You're making a claim that you're the trustee, but you don't have any documentary evidence to substantiate that position. Some claims have to be documented. Fiduciary roles have to be documented with clear evidence. It can't be done just by you claiming something. Capacity is conferred, not claimed. This is pattern 4 in its most concentrated form. This is not separate from SBC membership, not at all. This is the students can. I uploaded this document in the back of SBC University. I'm just selling it with. I just chose to share this one. Now I got another one, the right to be left alone. But private ordering, I wanted to basically manage expectations about people who come over to SBC University. Because when they come in there with this expectation that I'm teaching them something, some magic doctrine that's going to get them out of any situation that they find themselves in, and that doesn't exist. That doesn't exist. There's never was this thing where they don't have jurisdiction over you. Back in the day, very few people were using that defense, and it grew. Now it exploded, and everybody's using it. Back in the day, everybody was doing acceptance for value. Okay, they weren't using this defense, and so I'm trying to manage this because what has happened in this space is that the echo chambers through the social media have blown it up, where they got everybody thinking that they can do whatever they want to do, and they can't be touched, and it's really creating a lot of civil disobedience. And a lot of confrontation with police officers and people starting to lose their life. And I'm just attempting to try to correct that because it's going off the rails too far. Plain obvious. Okay, It's got something called proof of claim. That's what we're talking about. If you make a claim, can you prove it? What type of question is that? Use of all claims verbal or can I claim? No, all claims aren't verbal. They have something called proof of claim. I know you're in this space. You've heard that word, proof of claim. Where's your proof of claim? You got to be able to prove it. You can claim nationality, but can you prove it? Did you take a blood test? You said, well, I have Moorish nationality. I'm going to claim my nationality. You claim anything you want to claim. Where's your proof? Court is about proof. You can claim whatever you want to claim. Where is your proof? And proof is not a declaration. That's not proof. I don't give a damn what your issue is. You're not having an issue with me. See, that's how you're trying to style that. You're having an issue with the law. Okay? This is what the law says. I'm sitting here giving you references and everything, and you can't understand what's being said. These are authorities that I'm providing you with. It's not me saying this. Listen what he read. My issue is that you say claiming something means nothing. It don't mean nothing if you can't prove it. That should be common sense. That should be you can claim I'm the father. A woman can claim I'm the father, but when I take the DNA test, it proves I'm not. So her claim meant nothing. Why is it? What is it that you what is it? I'm trying to understand what you don't understand. What is it you don't understand? They've been saying proof of claim in this space since I've been in it. Where's your proof of claim? Y'all don't say that anymore. Or echo chambers, but we used to say it. All right. What about you being able to prove what you're claiming? Yes, claiming something don't mean shit if you can't prove it. I'm standing on that. Ain't nobody said claims are verbal. You can make a verbal claim or you can make a claim in writing. It doesn't matter. Can you prove it? Claiming is the first step, but it needs to be substantiated. Anybody can claim anything, you idiot. We know that's the first step. Y'all just want to start art, man. Get out of my chat, man. Y'all just start shit. They just let me get you out because you lack common sense. You lack common sense. You just want to make yourself known, and you're interrupting things with stupidity. That's just stupidity. We know that that's the first step. Why are you even raising that? That's common sense. It's common sense that the claim is the first step. Right? The claim doesn't mean anything if it can't be substantiated. If you make a claim, then you should have some proof to back it up, is my point. But if you're out making claims, which most of you do, that's the point. Most of you make claims that you cannot prove. That's the point. What is it you don't understand? Like when you claim nationality, you don't have any proof of your nationality. I see people do that every day. They claim nationality, don't have any proof of that claim. They just make a claim. See, look at this dumb stuff. Can a judge claim that one is the person? You don't know what a person is. If you are in the public, you are a person. If any time that you act in conduct in any public regulated space, that's not a person is not some straw man what you're thinking. Okay, that's the next thing. Your whole understanding of what a person is wrong. Okay, when you come into a public regulated space, your conduct is going to get classified. It's going to get defined. From that definition, they're going to first establish whether that conduct was engaged in by a natural person or an artificial person. Once that has been determined, the capacity of that person is going to get determined. See, in the public, they already got everything categorized and classified. all activity. So as soon as you come in, they're going to put you in one of those slots. You can't make up your own slot. You can't create a capacity like I'm a private state citizen. That's not a recognized capacity. All right, so they're going to put you in their own. If you don't come in with a recognized capacity that they recognize, they're going to give you one, and they're going to give you the worst one. And it's usually going to be an individual, one that has all of the liability. So you need to structure yourself first. So when you interface with the public, you can determine what capacity you're acting in. Like in the case of a trust, I'm coming in the capacity of a beneficiary or a trustee. But if you're a beneficiary or a trustee, there has to be some written documentation substantiating that. You just don't declare that, or some conduct that you engaged in that created some sort of trust relationship, like in the case of a constructive trust. There has to be some conduct that leads to the creation of that. But you just can't declare that at a thin air or claim it. They just want to be heard. A lot of y'all just be wanting attention, man. You want attention. You want to say, I said something. And I hate it when they do that. Well, you say, I didn't say anything. I'm sitting here reading authorities to you where you can go and verify that we're reading the UCC. We're reading documentary authority. This is the structure of the government. It operates in the public, and you're not going to change it, no matter how much you don't like it. I'm saying something. I ain't said nothing. The law says an unsubstantiated claim is frivolous and is going to get thrown out. I didn't say shit. The recurring execution failures. Signing as trustee when no trust holds title to the property in question. A trustee of nothing binds nothing. Signing for an entity without checking whether the operating agreement, bylaws, or resolution actually confers authority on that person from that act. Many governing documents require member or board approval above a threshold. Relying on a power of attorney that is terminated, was never durable, or does not cover the transaction class. State law varies. Acting for an entity that was administratively dissolved and never reinstated. State law varies. Each of these produces the same outcome. The instrument is voidable or void as to the purported principle, and personal liability may attach to the signer. Verify authority before execution in writing every time. The spoken word flies out the window. The written word remains forever. That is a principle of law. That's not me saying nothing. That's a principle that you can go and verify for yourself. Substance controls over form. This is the real study of the law. That's why you don't like it, because it's not, a lot of people, you have a problem with it because it requires study. It's easy to go get in a pity party over the echo chamber. Y'all just sit around and talk about something and pull out statutes, just randomly select statutes and say, see here, this is what this means, and doing things like that. That's easy to do. This right here is going to require you to actually engage in real study, but you're not going to want to do that. And that's what we're talking about. A lot of people in this space are lazy and ignorant and dangerous because of that. You're dangerous. You're dangerous because of that. The recurring execution failure. Signing as trustee when no, I already read all that. 5.3, same objective, two instruments. The recurring pattern is that the objective is achievable and the choosing instrument is wrong. All right, because you don't, okay, I have a document called the verification doctrine. I'm going to put it up and make it available in my store, okay, because I did a lot of intensive research on these documentary footprints on basically verifying somebody's authority. That's what it is, the verification doctrine. It applies to every branch of law. And I think it is my goal. I think it is my star of contribution that I am going to be contributing to this particular space. And no, it is not free, because I took a lot of time to put that together. So instrument, keep a business dispute out of court. Instrument that fails, instrument that works, fails. Declaring the court to lack authority. That fails. What works? An arbitration clause with a named administrator, seat, rules, and arbitrating section method. Drafted before the dispute. That goes back to what that general told. He said the problem with the civilians is they don't understand that their rights are enforced through contract. Man, when I read that, that stuck with me for so long, and that makes total sense to me. It makes total sense what he was saying. He said the problem with the civilians is they don't understand their rights are enforced through contract. Avoid probate. Fails, asserting that probate does not apply. What works? A fully funded revocable trust with clear distribution standards and successor trustee provisions. Probate is avoided entirely by the ordinary operation of law. Limit exposure of personal asset. What fails? A declaration of exemption of a nominee arrangement. What works? An entity properly capitalized, separately banked, formality observant, with adequate insurance, plus for future claims, appropriate trust planning within fraudulent transfer limits. Once again, these are compliance things. Once again, you want I want to attend our webinar tomorrow with Dr. Brewer. All right, that's what he's going over, compliance, how to structure these things and how to put them together. Compliance, and that's what I do on Tuesdays and Thursdays with our private trust class. I'm teaching you compliance. I'm teaching you how to put a trust together where it will survive scrutiny in a public forum. Control who may participate in an activity. Fails. Styling a public-facing operation as a private membership association. What works? Genuine associational structure with real admission criteria, real internal governance, and no public solicitation, plus compliance with whatever regulation attaches to the underlying activity. Reduces dealings with regulators. Fails structures whose purpose is opacity, which reliably increase scrutiny. What works? Choosing an activity, entity, form, and transaction structure whose compliance profile is simple, and then maintaining it. This is administration. Once again, you're going to learn this tomorrow with Mr. Brewer. All right, this is a skill that you have to learn. Being private is a skill. It's not a decoration. It's not throwing together these papers that you're getting off script and things like that. It's none of those things. You need to throw all that in the trash. You need to throw it all in the trash. Everything on script needs to be thrown in the trash, just about. 90% of that stuff on it needs to be thrown in the trash. Resist an unlawful government act. Fails. Notices, affidavits of status, or unilateral revocations. What works? A timely, specific, properly preserved objection, a motion to suppress or dismiss under 1983 or statutory action, an administrative appeal taken within the deadline. The completeness of the principle, where the leverage actually is. Court involvement in a private relationship almost always begins the same way. The relationship encountered a question the parties never answered, so someone asked a public institution to answer it. This is one of the things about drafting your agreements, what we learned in trust law. Okay, you got to make sure you cover any eventuality. But that's difficult to do if you don't have any experience in dealing with trust. There are going to be things you haven't thought about or you haven't encountered. This is the reason they have the Uniform Trust Code. It's a default provision. However, you do not want to subject your documentation to the Uniform Trust Code or the interpretation of a chancery court. Okay, because the intent of the settler is what controls. But you need to make sure that intent is clear, is cogent, it lacks ambiguity. Okay, and that is why sometimes these documents are 75 pages long. It's that long because you want to make sure that everything is covered, that nothing is left out, and nobody can leave something left to somebody's imagination. A private form is a form you agreed to have a private adjudication. That's an arbitration. You haven't ever read an arbitration agreement? Arbitration is a tool of private ordering. Where the leverage actually is. Court involvement in a private relationship almost always begins the same way. The relationship encountered a question the parties never answered, so someone asked a public institution to answer it. Every question your instrument answers in advance is a question no court has to answer. Every question that leaves open is an invitation. This is what primary thing we learn in trust drafting. Primary thing. This is the thing. My students, they hear me say this every day. No ambiguity. This is why we go through all the case law. Why you have to read a lot of case law. If you're going to understand trust, you got to read a lot of case law. Ain't no way around it. There's no way around it. There's no way around it. There's no way around it. It follows the effectiveness of private ordering is a function of completeness and clarity, not of distance from government, and not of assertiveness. The most effective private ordering is usually the most boring, thorough, specific, conventional in form, and drafted long before anyone is angry. And that's an important aspect too. Like even with offshore asset protection entities, it got to be done before anything happens. It has to be done before anything happens. You can't do it after the fact. You have to be proactive, not reactive. The instrument that governs nothing. The most common real-world failure in trust planning is not a drafting failure. It is a funding failure. A trust is set up as a set of instructions attached to property. If no property was ever transferred to the trustee, the instructions attach to nothing, and the document governs nothing, however well drafted. Funding is a series of ordinary, unglamorous public and private acts, deeds executed and recorded, accounts retitled, entity interests assigned on the books, beneficiary designations updated, promissory notes endorsed. A pour-over wheel is a backstop, not a substitute. Assets that reach the trust through it pass through probate first, which defeats the object. Structural, the same failure appears in every instrument family. An operating agreement for an entity never formed, a security agreement never perfected, an arbitration clause in a contract never signed. This is also the completeness principle applied to execution rather than to drafting, and it connects directly to pattern 4. If title did not move, control and benefit did not move, and nothing changed but the paperwork. Stated as a drafting rule, foundations before remedies. The instrument written before the dispute determines whether a remedy ever has to be sought. This is where the discipline pays, and it is not glamorous. It's not, because it requires a lot of study, of which a lot of people don't want to get involved with. So here's part 6, diagnostic procedure. Run these 8 questions in order before drafting any instrument or advancing any position. Stop at the first one you cannot answer with a citation. 6.1, the protocol. What activity is actually being conducted? Describe it in conduct terms, what is done, for whom, and what consideration, without using any label from the instrument. Classification follows conduct. Number 2, is that activity regulated, and by whom? Federal, state, local, state regulation, licensing board? If yes, the regulation is the floor. Identify the specific provision. Number 3, who are the parties and who is affected but not a party? Creditors, spouses, minors, employees, customers, taxing authorities, the public. Nothing in your instrument reaches anyone in the second group. 4, for each term you want, is the governing rule mandatory, default, or altering? If mandatory, stop. Redesign the objective. If default, proceed. If altering, comply with its form precisely. 5, what makes this instrument enforceable and in what form? Name the statute or doctrine that gives it effect and the tribunal that would apply it. If you cannot name one, the instrument has no effect. Number 6, does the arrangement change actual control and actual benefit? If the same person decides everything and receives everything as before, the arrangement will be disregarded regardless of drafting quality. Subsection 4.1 and subsection 5.4. Who is signing and in what capacity, and what confers that capacity? In other words, you sign in a certain capacity, you should have a delegation of authority, the documentary footprint that we can trace back to that gives you the authority. Name the instrument, statute, or resolution that gives the person authority to execute this document for the principal, for this principle. If the answer is the signature block itself, there is no authority. And number 8, has it actually been done? Has property actually been transferred? Filings actually made? Register updated? Accounts retitled? An instrument that was drafted but never executed on the ground governs nothing. Warning signs and any material you are given Apply these to any instrument, seminar, forum, or argument presented to you, including material from this institution. Citations without pin sites or citations to cases that do not exist. Pull every case. That happens a lot in this space. They will put cases up, and when you go and look it up, what's being said is not there. They do that a lot in this space because they want to try to act like what they're saying has some sort of authority. That's why you have to actually pull the case. That's one of the biggest problems in this space is people like to cite citations of authority they have not read, and they don't know whether or not what is being said is in there. People, they have planted a lot of those on the internet. Some of them have been circulating for decades. Quoted language that does not appear on the cited page. This is the most common defect in circulated material, as I just stated. Reliance on dicta, dissents, or concurrences presented as holdings. Reliance on decisions that have been overruled, superseded, or confined. Always check subsequent history. That right there is shepherdizing to see whether or not if it's still good law. Like the guy came the other day talking about right to travel from 1910 case. I'm like, look, man, that's not like that today. That's not good law anymore. That's back when cars, the speed record then was 39 miles an hour. Bicycle could go like 22 miles an hour. Apply these to any instrument, seminar, form, or argument presented to you, including material from this situation. Reliance on decisions that have been overruled, superseded, or confined. Always check subsequent history. Any claim that a particular form of words produces a legal result without regard to conduct. That's the biggest thing. They think the words control. I'm not that person argument. So that means my conduct, you cannot adjudicate my conduct. That's the biggest sovereign citizen idiocy that is currently being, that's number one on the list. Number one on the list. And what the majority of the videos on YouTube that you see are all about. Any claim that a body of law does not apply to persons who decline to accept it. That's not real. I didn't contract to this. Your conduct is what made you liable for it, not the fact that you had to expressly agree to it. You don't have to expressly agree when you go in and eat some food in a restaurant and you get up and try to leave without paying. You didn't sign anything. An absence of any statement of what happens if the argument fails or of what has tried it and what its reported result was. The last one is decisive. Every technique in this area has been tried. The reported cases exist. If the material presenting the technique does not tell you how it fared, that is because it fared badly. And that omission itself is the answer. Once again, I said, if you go in the echo chambers, even though they got thousands of videos on YouTube showing examples of the things that they're saying not working, you never see not one single person in any Facebook group post not one of those videos to let y'all know it doesn't work. Verification exercise. Y'all can do that on your own. One sentence rule, memorize this. Private ordering is the power to write the terms the law leaves to you. It is conferred by law, exercised inside law, binding only on those who agree to it, and effective only where the conduct, not the label, matches what the instrument describes. Substance over form. I already got a private ordering part of it. It's called SBC University. Called SBC University. All right. I just read that to you because I wanted to make sure there's some people that can't read, so I'm reading to them. So go back and listen to this. As I said, the document is under the video. It's under the video, so you can click on it and download what I was just reading. You don't have to ask me where the document is. I provided it for you. You can download it. You can research it. I would like for you to research it, expand on this, put it in your AI. I encourage you to do that. Upload it to your AI. See if you can expand on it. Try to find some defects in it or some flaws in it. However, I think you're going to find out that it is solid. Also, that this is where privacy exists at. This is what we're trying to teach you and how to conduct your affairs privately. Once again, tomorrow at 7 p.m., we are conducting a private placement memorandum seminar and to understand how you can raise capital privately and conduct your affairs privately, and the structures and compliance mechanisms that need to be in place for you to do that. The same thing exists in my space with private trusts. Okay, there are compliance things that we have to go over. You just can't write a trust indiscriminately or just however you want to and put whatever you want to in it. Okay, there has to be considerations that need to be taken into account. Okay, what type of powers are going to be conferred on the trustee? Do you need a trust protector? You don't always need a trust protector. Usually a trust protector comes when the assets are starting over at $500,000. All right. Are you going to have a asset protection trust? What kind of trust is it? Is it an investment trust? Is it going to be domestic or foreign? Okay, is it going to be a spendthrift trust? Is it a holding trust? Okay, all these things have to be taken into consideration. Okay, where's the status of the trust is going to be? All these things have to be taken into account. It's more than you just putting together a document on ChatGPT and then printing it out and now saying I have a trust, and you file some sort of certificate of trust down at the real estate office, and now you transferred your property into the trust. Okay, it's a lot more to it than all of that. That's the formation of a trust. That is not the substance of the trust. The substance is what controls, not the form. All right. Hopefully, I don't see any questions in the chat. Definitely appreciate you making and taking the time to do that and all the great info you have given, bro. You're welcome. You're definitely welcome. I would encourage you to get the document that's under this video. I would also encourage you to become a member of SBC University. It's $99 a month. You get 16 classes for that. I would encourage you to come to class because you're going to learn this. You're going to learn to love it too, because once you really see how it actually works, and it's not that confusing and it's not as hard as you think it is, you're going to get an enjoyment out of it, and it probably open other doors and open up your creativity to all the different opportunities that are available to you. You know what I'm saying? Yeah, the class is going to be the same with Mr. Brewer. Yes, it's going to be tomorrow at 7 p.m. Be there early. It's on private placement memorandum. What he's teaching you is compliance. Everything that we're discussing right here. He's teaching you how to structure yourself for compliance. Even though you're engaging in the raising of private capital, there are public regulatory authorities that you have to take into consideration. And that's with anything that's conducted privately. As I said, the public is always operating in the back. This notion that I'm completely private and therefore I'm totally not subject to anything in the public, it doesn't exist. It doesn't exist. You can reduce your encounters with the public, as well as the fact you can modify your relationship with the public when you appear in the public. That's what capacity is all about. You controlling the capacity in which you appear into the public. That is what private ordering does for you. It allows you to control what capacity and classification you're going to be subjected to, and therefore what laws you're going to be subjected to in the public. So you have to structure yourself strategically in the private with considering the fact that if you ever have to go into court, you already know in what capacity you're going to appear and what laws and rules are going to apply to you. The document is under the video. I've said it several times. There's a link under the video in the description of this video. All you have to do is click on it and you can download this document. This is a very, very thoroughly put together. I took a lot of time putting this document together. No, I just didn't put something into Claude or ChatGPT and spit something out. Okay. As a matter of fact, me reading it, I see I need to make some improvements upon it. There's some things I want to add into it. However, it covers a lot of what I want. 98% of the things that I want to say, it covers it very thoroughly. And this is to try to help you to understand the demarcation line that separates public and private, because it has been my contention ever since I've come on to these platforms that is what is lacking in this space. A thorough understanding of what constitutes public and what constitutes private. And this notion that private individuals or citizens and things like that, that they are fully exempt from any public regulatory authority, and that is a lie. That's going to get you arrested or maybe even seriously injured. Okay, and you're going to be in the wrong. You're making an argument and you're not in the right in making those arguments. You can call me a agent all you want, but one of the things you can't call me is wrong. Best believe that you have not investigated or studied any of this to the degree that I have, especially if you get in all your information from an echo chamber and never once has stepped foot to a law library or opened up a law book, which is the majority of people. All right, so are there any questions before I go? I'll answer a couple of questions. How much time I got? I got 5 minutes left. I got 5 minutes left. I appreciate you. I appreciate you too. You're welcome. Peace to the guys and have a blessed day. Thank you so much. You're welcome. I appreciate you. I appreciate you too. I see you in class. I appreciate you. Appreciate you. I appreciate all of you too. Shalom to the Elohim. I appreciate all you too. All right. Well, I will see y'all in class tomorrow then. Also, once again, before I go, register. Let me show you how to register for this class. Let me put this on the screen before I go. And put this on the screen before I go. All right, we go to SBC University. How you register for the class? Simple. You go to the shop page. All of them right here. DTC, private structure. There's the master class right there. Click on that, and you can register for the master class. All right, you'll get a registration link after your payment has been confirmed. But this is probably this is some important information. We're setting up for some things. You need to make sure you have this information so you can understand private ordering and compliance. This is what it's all about. I don't know what else to say. I don't know what else to say. That's how it's done. It goes on. It says, "Have you seen the Supreme Court? The Supreme Court of the United States ordered a rehearing in bank on U.S. versus Hamony, with Justice Thomas writing the opinion challenging the commerce clause." Well, I think so too, because that's how the government sees its jurisdiction in a lot of matters. The commerce clause is that, yeah, Article 1, Section 8, Clause 3 has caused more litigation in the federal courts than any other clause in the Constitution. And they don't know the limits of it. That's the thing about it. Justice Thomas is probably trying to determine, okay, that's what Scalia was saying before he disappeared. He was saying the same thing. Y'all keep bringing these cases. Every single case you come in here is commercial as commercial in matter. He said, which case is not commercially related? We have a government, a limit. We have one of the principles of the Constitution is limited government. They want to know what are the limitations on commerce. Because see, they interpret it as not only everything that is commerce, but everything that materially affects commerce is inclusive as well. Which where's the limit on that? Justice Thomas is trying to uphold the republic, but so that's why that's why they're gonna demonize him. He's gonna get demonized. The people who get demonized is the people you pay attention to, because they're the people who are fighting against the New World Order, and it's progressive, which is progressive, it's progressive ideology. Lil Bootsy got bought. Well, the same thing happened to Birdman too. When they gave him that, you can get on the internet right now and look at that. It's a video of Birdman talking about he had diplomatic immunity, and he put the paper up showing his diplomatic papers, and on the paperwork, diplomat is spelled wrong. You go on the internet and see it right now. They finessing these people out of money left and right, boy. They finessing them out of money left and right. Does antitrust law applies to what you're explaining today? What do you mean antitrust laws? No, it don't apply to what we're talking about today. No, it don't have any application. And not as far as what we're doing, it doesn't. But I'm sure it has some application if you engage in that activity that it covers. No, that master class don't have nothing to do with me. That's him. That's not an SBC University real class, really. I'm hosting it, but that's his class. That's not an SBC University type of class. That's his class because I asked him to come and do it, and he didn't he resisted doing it for a long time because he didn't really think. I understand his thoughts. It's like are people even interested in that type of subject? I thought that you were because what? Y'all constantly talking about CUSIP numbers. You talking about the DTC and securitization and the redemption of a bond and all these kind of things right here. Okay, well let's really get into this and look and see how all of this really works. All right, how does this from a professional that does it on a daily basis? Not learning from other people in echo chambers who've never even dealt with securities in any capacity whatsoever, but they these experts on it. And they're telling you what you need to get your CUSIP number and track down your security, telling you all this stuff. And I'm like, that's not even how this works. Yeah, brother Truth, if you want to keep brother Truth, if he wants to debate me and he wants to get crushed, he can do that. But I don't care about any of the new people that you go and get. Brother Truth is a newbie. He is not anybody different than anybody. I don't look at him in any capacity than anybody else. I don't need to debate him because he's a newbie. He's teaching the same misinformation that everybody else is teaching. Now you're going to bring him up like that, and you're going to bring it at. If you want to get him slaughtered or something like that, you can bring him in too, and you could go and tell him, and you can go show him this video. But I've been doing this for 20 years. I'm not standing down to anybody who just showed up on the scene because they are just regurgitating. Why I'm going to debate somebody who's just regurgitating the same thing that we've been talking about for 20 years? He hadn't offered anything new to the space. Nothing. Not anything. What do you mean debate? Nothing. He ain't offered anything new. It's the same thing. He has about the same general understanding anybody else. These people that y'all calling gurus, they just gurus to people who don't know anything. You seriously think he's going to be able to debate me? And I understand securities and all these things. I understand. I've been doing this for 20 years. You think this young person who just showed up on the scene has the requisite knowledge and experience, and I have experience and going into the courts as well, and you think they can debate me on something? I tell you what, you put up $100,000 and put it into escrow. Put up $100,000 and put it in escrow. If not, don't come at me talking about things, and I'll provide the platform. And you can go get all these people. You can go get the other guy you're talking about, Wolf. You go get all of them. You go get your white boy. What's his name? You can get every one of them, and you can put them on one team, and I'll be on one side. I'm giving him some partners. You go get those 5 people, your 5 top people, and I'll go against all of them. I don't care who disagrees with me. He's not no authority in anything. He's not no authority. I don't care if he disagrees with me. He's not that. You made him authority because you don't know anything. You don't know anything either. That's why y'all believe what he's telling you, or anybody's telling you for that fact. You're not an authority. Y'all have these AI computers and everything. Y'all should be answering your own questions now, but you're not doing it. But you will be in about a year from now. That's why I'm not worried about anything. Y'all all coming to this right here. You can't deny private. You can't deny any of the things I'm saying. Let's get into a conversation. Let's get into an esoteric conversation. Let's talk about bonds or what actually goes on into the courtroom. Y'all want to say that it's an admiralty equity jurisdiction. Y'all want to use words like exclusive equity and things like this. I guess you're trying to make some sort of claim that some sort of constructive trust has been created and that the government is engaging in some sort of unjust enrichment, which you could make that argument with the taking of the gold. All right, but I've already done all of that research onto that. Okay, because when you discharge a debt, you're making a claim against the United States for the taking of the gold. Okay, now you have to have proof of claim to substantiate that. How would you go about substantiating that? What evidence would you present? Ask Brother Truth that question. What evidence is he going to present in court? Do you understand public and private? Do you understand that you cannot declare privacy in a public regulated space? Who's going to debate that? If Brother Truth, you're saying Brother Truth uses private member associations? Is that what I've never seen him talk about it. We talking about to use private member associations. I've never seen any of them dudes talk about any of that stuff. They talking about it now. They talking about it now because but ain't nobody was talking about private member associations before me. I don't know where y'all lying and everything. Y'all lying. A private member association still is subject to public regulatory authority. So it doesn't matter. You're still not going to evade public regulation because it operates within that framework. I don't know why they want to see somebody debate me because I'm kind of itching for it. I got time today. I'm kind of tired of them talking and everything. It's just that they got to come to me. I ain't coming to no new person's platform. I got Skype. I got my thing set up where I can make a Zoom. I can bring people in on Zoom. We can do it all day long. You ain't said nothing. I don't even understand why y'all bring these new people to me as if they on my level. Brother Truth is not on my level. Brother Truth is a newbie. He's a newbie, man. What are you talking about? Wolf, those are newbies, man. They've been doing this probably about 3-4 years. He had a good marketing campaign, and he's done very well for himself. He's a smart brother. He understands the information moderately, but in no kind of way in circles of us who have been doing this for a long time, or we look at them as experts in this in any capacity whatsoever. That's good for you. You're following them. So, and I don't know why y'all try to create these arguments. Because, see, like, I don't even mention the brother. But if you're going to bring and mention him on my space, I'm going to tell you the truth. No, he can't debate me. He's not ready for me. Not no more. He's not ready for me. They're not on this level. Okay. I got experience, a lot of experience, not just research, experience. And I know what works and what doesn't work. I'm not interested in debating anybody, and I don't need to collaborate with them because they don't have anything I need. Now, I will say this. If they want to come over to SBC University and teach and we make some money or something, we can collaborate on that. But we can't collaborate on doctrine or anything like that. We can collaborate on making money. All right, because I've already carved off my path, already got the doctrine for SBC University. And I already know what I'm going to teach and where I'm going. And I understand the framework that I'm operating in. I don't need anybody to educate me on it. I don't need anybody to add to it in any capacity whatsoever. Now, if you want to bring, that's what I thought about doing because I got like Alex Hermosi, I got the same type of platform that Alex Hermosi has. They could come over there realistically and put everybody in one place and we could all share the wealth. That would be ideal to do. That would be ideal to do because I put a lot of money into what I'm doing. I'm not collaborating with anybody. I've invested in what I'm doing. I'm invested in it. So yeah, don't do that. That's insulting to me. You insult me. You insult the OGs when y'all think that the new people, you know how long it takes to learn this information? You can't circumvent 10,000 hours of study. You can't, there's no way you can get around that. So if you've only been doing this 3 or 4 years or something like that, you're a newbie to me. You just gotten to the point where you're functionally literate with the information. So if you want to do that, that's fine with me. I have no problem with that whatsoever. I will debate any of the in this space, any of the people right now that you're looking at as gurus. If you want to debate me, you can, but you're going to make it worth my time. Because I'm getting tired of y'all coming on my space, bringing up other people's names, as if they are some sort of authority. They're not an authority. They're just a person operating in an echo room like anybody else. None of this stuff is written down in writing. None of this stuff is written down in stone. None of these processes that y'all trying to do, y'all trying to understand a framework and how to operate within a framework, and I'm giving you the framework. Ain't none of y'all talking about private ordering and private member associations before I was. Stop lying. Arbitration is a part of private ordering. Did you just see what we were reading right here? When you put together a private member association, I'm putting together a private member association operating through a trust, but I have to have trustees first. And that's what I'm training at SPC University. So you don't know anything about that. All my students understand what I'm doing. All right, so I don't understand what you're asking. Are arbitration agreements a part of private ordering? They are, yes, very much so. I mean, that's basic. That's basic. There is no arrogance in use of veiled statement. They're just it is reality. There's no arrogance in it. It's an insult. You know, it's almost like these young guys. They say LeBron is better than Jordan. It's like LeBron is not better than Jordan. LeBron is not even in a class of Michael Jordan. That's not even in the same class. But you know, but you got this new generation. That's all they experienced was LeBron James. So they think LeBron James is the greatest ever. And all of us who've looked at the whole body of work, because we've been watching basketball since 1975 and seen Bird and Magic and Dr. J and Kareem and Jordan, and we done went through all Barkley and went through all these people. Now you get to LeBron James, Kobe Bryant, and everybody, and they trying to say he's the best. He's like, he's not Jordan. Jordan shook up the world. He is not Jordan. He's not Jordan, ain't even close. So that's the same thing. It's like, yeah, he might be good at what he's doing, but I've been doing this for 20 years. You're not going to, how are you going to fight that? You're going to fight that? I've been doing this 20 years. I've listened to him, and I let them go. I don't even mess with them. I let them go. I let them do what they do. And now you're going to get an assault charge and everything because you're trying to stir up something. Because those are the devils. I want y'all to understand. People that do that, they come into the chat, try to pit people against each other. Always be looking at the messenger. It's a devil. That's what little demons do. They whisper in your ear and everything like that. Instead of just saying, oh, he would, like he's some sort of authority and not respecting the fact that I've been doing this for 20 years. It's an insult is what he just did. As if you don't know what you're talking about. I've been doing this. So I've just been doing this for 20 years and I just don't know what I'm talking about. I just don't know what I'm talking about. I don't even bring the brother up, but the brother was teaching private member associations for these 5 years, but your elder best is the game. Private member associations is just contract. It's just an agreement. It's contract. Contracts have been taught forever. You have to have contracts. Contract is what governs. I've been teaching public and private forever, and it don't seem like none of y'all understand that. That's the thing. Your private member association don't mean shit if you don't understand the demarcation line that separates public from private, and you sitting here and thinking you can declare privacy and then operate in a public regulated space with some sort of status of private through some sort of declaration, or because you're a member of a private member association. None of that defeats the public. Just because you're a member of a private member association, none of that means anything. When you come into the public, you are subject to public regulation. If anybody wants to debate that, I'm going to crush them. So go run and go tell. Run and go tell. They're going to get crushed because all the law supports what I'm saying. And it doesn't support any of the things you're saying. All you can do is come through with theories or what you feel like something is, but you can't substantiate it. I mean, it's okay, it's cool, but I mean, I don't know if they thinking that somebody gonna back down and everything. I'm not backing down. What are you talking about? I'm an 800-pound gorilla, man. I'm a killer. You don't know that? I'm an 800. When you be coming to me like that, you don't know who you're talking to. I got time today. I'm waiting for somebody to use my name incorrectly. I'm waiting for it because I ain't got nothing to do. You know what I'm saying? I'm waiting for it. I'm waiting for it because I'm usually quiet. I don't mess with anybody. I don't say anything about anybody or anything like that. I keep to myself. I don't do that because I do my own research because for probably the first 10 years, I did listen to other people. Okay. And that's what a lot of you are doing. You don't conduct your own independent research, which shows because you got some guru in something that you're talking about instead of conducting your own independent research into it and finding out what it's talking about yourself. I know they don't even know I was on the radio for 7 years debating people. You know, that first 7 years of me doing this, that's all I did was debate, on high frequency radio. They, like I said, they knew. They come into this space new. That's what just gets under my skin. They come into there new and they think they know something, and you don't know anything. You should just shut your mouth. If you've been doing this for like 3 years, you should just shut your mouth. You shouldn't even be quiet. I say 5 years. If you've been doing this for 5 years, you shouldn't even be talking. You shouldn't even be talking. Well, Blog Talk is now defunct. Doesn't exist anymore. So please refrain from doing that. Don't be bringing other. Do you do the same thing over on their platforms? I wonder, do you do that on their platforms? Do y'all go over on that platform and say, you know what? I want you to debate Brother Yusuf Ale because he gonna disagree with what you're saying on public and private and public regulated spaces and a certain private rights. Why don't you? Do y'all go over there and say that to them? Y'all go say that to them? Y'all go on their platforms and say that to them? No, I don't. Yeah, I do come off intentionally like that because yes, I am a leader in this space, and I do come off as I'm an authority because I am because I haven't seen anybody else in this space that I can say does have more knowledge than me. So it's not that I'm the only person that has knowledge; it's that 90% of y'all don't know what the hell you're talking about, and I'm standing on that. So yeah, if I'm coming off as arrogant or that I know everything that a lot of people don't know, yes, that is precisely correct because I put in the work, and my students see I put in the work and I don't see other people putting in the work. I'm not just arbitrarily and capriciously making statements. I can back up what I'm saying. So if you know you sounding like, oh, you don't like how I'm saying it. That's what sound makes it sound like a woman. You don't you don't like how it's being said. They mad you don't let them play with my intelligence. I don't. I don't let them play with my intelligence. I can't be easily deceived. I know what I'm talking about. So if that's what you want to do, you can go and run and tell. It don't matter to me. But don't come on my space bringing up other people who you think are going to take me out or something like that because we can see it. We can make that happen and see if it's going to be true or not. And make sure you have some money because you're going to make it worth my time. Got it? All right. So anything. With that being said, I don't know everything because there is a maxim of law that says many men know many things, but no man knows everything. No one is claiming to know everything. All right, but what I'm trying to do right now is give you a firm foundation. You know, you want to talk about securities, I'm giving you an avenue to learn about securities from a professional, somebody who actually does it, somebody who actually monetizes debt, somebody who does it, a real private banker. And with that being said, that's it for me today. I appreciate everybody for tuning in, and I will see you later on. Like, comment, and subscribe. I'd be really interested. Hit the notification button as well. I'd be really interested in seeing your questions under this video. And like, comment, and subscribe. And I'll talk to y'all later. Peace. I'm out.